Welcome to the democratic process. Your call to jury duty may be the most important civic role you perform outside of a voting booth as a participant in this great democracy. Here in New York, with our system of checks and balances, it's the responsibility of the state, as represented by the prosecution, to present the evidence against any person accused of a criminal act. It's the duty of a grand jury, you people sitting here today, to review that evidence and determine whether that accusation is legally justified. As grand jurors, your decisions must be based on the evidence and the law. And as you serve, always remember that our grand jury system is designed to help protect the rights of citizens and uphold the laws of the land. I'm Leslie Stahl of 60 Minutes. You are ready to begin your grand jury service. But many of you may be asking, what is a grand jury anyway? And how is it different from a trial jury? Well, those are really good questions, and here's a simple, brief answer. A grand jury decides whether or not a person should be formally accused of a crime. If that decision is yes, the grand jury issues what's known as an indictment. An indictment is a grand jury's formal written accusation of a crime. A grand jury does not decide whether the accused is guilty or not guilty. That's the job of a trial jury. There are other important differences between a grand jury and a trial jury. For example, the burden of proof. A grand jury determines whether there is legally sufficient evidence and reasonable cause to believe that a person committed an offense, whereas a trial jury determines whether the prosecution has proved the accused guilty beyond a reasonable doubt. A grand jury proceeding is also different from a jury trial because a grand jury typically hears only from the prosecutor and the prosecutor's witnesses. But there's one thing about grand jury and trial jury service that's the same. You must not read or listen to news stories about the case, and you must not use the internet to search for information about the case, the lawyers, or any individuals involved in the case. Your decisions must be based only on the evidence presented in the grand jury room. Now, I'm here to give all of you an idea of what you'll be doing as a grand juror. And by the way, I think you'll find it a fascinating experience. First of all, each of you will receive a copy of Article 190 of the Criminal Procedure Law, which governs grand jury proceedings. This is the legal framework. But let's take a brief look at how the whole system operates. In most instances, the process starts when a person is arrested, though there may be occasions when a grand jury is asked to consider an indictment before an arrest. Now that's where your work begins. When you begin your service, you'll be brought into a grand jury room much like this. The configuration of the grand jury room may vary from county to county. As you can see, there are 23 of you, a number established in English common law centuries ago. The court will choose your foreperson and assistant foreperson. You will choose your recording secretary. A stenographer will be present to record the testimony and instructions, the official record. Once you're seated and sworn in, the prosecutor will arrive to begin presenting the first case to you, a presentation that will set forth the evidence against an alleged offender.
Good morning. I'm an assistant district attorney in New York County. I'm here this morning to present the case of the people against John Doe. At the conclusion of the presentation, I will ask you to vote on one count of robbery in the first degree. You will hear evidence this morning from...
The presentations you'll hear from an assistant district attorney may include homicide, robbery, grand larceny, narcotics crimes, possession of stolen property, rape, sodomy, assault, arson, kidnapping, burglary, possession of weapons, practically the whole spectrum of the criminal law. This doesn't mean you'll necessarily hear these cases in your grand jury term. It simply means you could. The prosecutor will present the case, call witnesses, and instruct you on the law. You will note that no judge is present during grand jury proceedings. The entire presentation is handled by the prosecutor, but the judge who oversees the grand jury is available should the need arise. Most presentations take only a short time, although some cases might run for several days or more.
Yes, sir.
Was it light enough inside the building for the victim to take a good look at the man that attacked her?
I'll have the witness come back in and ask her that question.
If you have questions for a witness or questions about the law or about the evidence, you may ask these questions of the prosecutor during the presentation, or you may ask to speak to a judge. The prosecutors and judges are your legal advisors. And as you will read in Article 190, you are forbidden by law to seek or receive legal advice from any other source. You should also know that the accused person has a right to appear before the grand jury on his or her own behalf. He or she may also ask the grand jury for permission to present other witnesses for the defense. But keep in mind that no accused person has a duty to appear or present witnesses and may not even know of the grand jury proceeding. As a result, it's very rare for an accused person to appear before a grand jury or present witnesses. And don't come to any conclusion, positive or negative, because the defendant does or does not appear. And perhaps this is a good time to remind you that all grand jury proceedings are strictly secret. It's against the law to reveal anything about the cases presented to you, and there are good reasons for this. This strict secrecy ensures that witnesses can cooperate fully. It encourages free and open deliberation among grand jurors, and it protects the innocent person who may be investigated but never indicted.
The shield of the people and the sword of the people. Now, we're going to talk about the Fifth Amendment in a second, but the very basic idea of a grand jury is that it is the shield of the people first, that it's going to protect ordinary citizens from unjust prosecution, from the king or the prosecutor, whoever has the power to come and just charge you with a crime. So, for instance, if you live across the street from the federal prosecutor and you decide that I'm going to toilet paper his house, he can't wake up in the morning and get mad and charge you with murder. He'd have to go to the grand jury first. So the Founding Fathers felt that this was so important that they had to throw it into the Fifth Amendment, the Bill of Rights. And let's read you that passage right now. No person shall be held to answer for a capital or otherwise infamous crime unless of presentment or indictment of a grand jury. So what this means, on the federal level, we're not talking about the state level here, that the federal government can't charge you with a felony unless they first go to this grand jury in order to get an indictment. So that is the great shield of the people. But it's also the sword of the people, because it allows the people to accuse and indict their fellow citizens for crimes based on probable cause. Now, so federal grand juries, there is a system. They do have words written down in the federal code. And the first one is that it can be anywhere between 16 and 23 people. So it fluctuates depending on the prosecutor in the district and what they're going for. But you also do not need unanimous consent. You only need 12 of however many in order to indict somebody for a crime. And now the differences really get wide. There is no defense. Okay? There is no defense lawyer. In fact, the prosecutor who runs the whole show, if he has evidence that shows that defendant, the person they're trying to indict, might be innocent, they're under no obligation to show the grand jury. So in a sense, the grand jury really is at the beck and call of the prosecutor. The prosecutor presents evidence, the prosecutor is going to present witnesses, and the prosecutor is really going to put everything that they want in front of that grand jury, and the defendant can't do anything about it. Now, grand jury members can ask any questions they want. They also have the power to subpoena evidence and witnesses. So it is a really heavy power. Grand juries are also held in secret, at least they're supposed to, and this is to protect the innocent from not having their name dragged in the mud, and also to prevent those jury members from not being influenced from outside forces when they decide to indict or not to indict. There's also no exclusionary rule that hasn't been incorporated into grand juries, so if the police find evidence and they've gotten that evidence illegally, it still can be used to indict you. It wouldn't be used at the trial, but it can be used to indict you. And there's also no screening bias for jurors, so they're not allowed to ask questions from the defense to try to get people kicked off that jury. So now why don't we take a look at some examples of grand juries, just in case you want to write about it. Now, it's important to note that some of the grand juries we're going to talk about might be grand juries led by prosecutors in districts and federal districts. But you can also have, and this is legal, to have special counsels put together and have grand juries just to be put together to investigate things like organized crime or corruption or political stuff going on. But one of the earliest examples was actually put together under the guise of Thomas Jefferson, who was going after Aaron Burr. He didn't like Aaron Burr very much, and he wanted to charge him with treason. So we actually went through 3 different grand juries, I believe one in West Virginia, one in Louisiana area, and one in Missouri, and he couldn't get the grand jury indictment. But he kept going for it, and finally they got an indictment in Virginia, and that case for treason was held by the Supreme Court where Aaron Burr was found not guilty. Now, other big, huge grand jury stuff that you should know is also special prosecutor stuff, and that would be related to Watergate. So in that instance, we had a grand jury that was subpoenaing, is that the word, subpoenaing? We're going with it, who was requesting material under the law from the President of the United States. And that would be the Watergate tapes. And that goes to the Supreme Court because Richard Nixon tried to say executive privilege. I can't show the grand jury. This would endanger national security. And in a unanimous Supreme Court decision, the Supreme Court said, no, you got to do it. So the grand jury is, in a sense, a fourth branch of government, and that the same protections for the president that they have with the legislative branch and the judicial branch in terms of executive privilege, they don't have in this investigative body that is seeking out whether a crime occurred or not. And of course, we know that's eventually going to lead to Richard Nixon resigning. And then after the fact, he actually appeared in front of that grand jury. Now, the first sitting president and the only sitting president to sit in front of a grand jury would be Bill Clinton. And this occurred in 1998 when Ken Starr, a special counsel investigating past crimes stemming from something called Whitewater, is going to subpoena President Clinton. And he's going to have to sit and answer those questions under oath. And eventually that's what's going to lead to charges down the road, which impeaches Bill Clinton. And then he goes to the Senate where, of course, he's found not guilty. And of course, we have current grand juries. We had one in 2016 that was investigating Hillary Clinton's emails. And of course, the big one now is Robert Mueller. We recently found out that he has a grand jury that has been put together that is investigating the Russia-Trump collusion story. And they, like other grand juries, have the power to investigate, to subpoena, to call witnesses under oath, and all under the control of Robert Mueller. And then they'll decide whether or not they want to indict for a crime. So,
jury service is one of our most important civic duties. The Sixth Amendment of the U.S. Constitution states, in all criminal prosecutions, the accused should enjoy the right of a speedy and impartial trial by a jury of the state and district of where the crime has been committed. In other words, any person accused of a crime punishable by law has a constitutional right to a trial by jury. The Seventh Amendment provides a similar right to trial for litigants in a civil lawsuit. So, how are jurors selected? If you are at least 18 years of age and a U.S. citizen, you could be summoned for jury service. Jurors are essential. They listen to testimony, review evidence, and render a decision in a civil or criminal trial. There are 2 types of juries, grand and petit. A grand jury determines if there's probable cause or enough evidence to charge a person with a crime. It consists of 16 to 23 people, and proceedings are not open to the public. A petit jury, which you're probably more familiar with, is also called a trial jury. It consists of 6 to 12 jurors who examine the facts and render a guilty or not guilty verdict in a criminal trial. Before a jury is selected, the court and counsel will question potential jurors to ensure an impartial jury, as required by the Constitution. This preliminary examination is known as voir dire. If a juror is biased, counsel can ask the judge to dismiss that person for cause. There are also what are called peremptory challenges. In some criminal cases, this allows counsel to excuse a limited number of potential jurors without stating cause if the attorney believes a juror will not serve the best interests of their client, but a juror cannot be excused based on race or sex. In some cases, alternate jurors are selected to take the place of jurors who may become ill during the trial. Alternate jurors hear the evidence just as other jurors, but they don't participate in the deliberation unless officially replaced. Before the trial begins, the judge or the jurors will select who will serve as a foreperson. This person diffuses arguments, ensures each juror has a fair say, and addresses any necessary correspondence or questions to the judge. During the trial, jurors will hear opening statements from both parties on the reasons they are in court, testimony of witnesses, and evidence introduced, and finally, closing arguments. Throughout the trial, proper juror conduct is essential in order to be fair on all sides. In other words, jurors must not discuss the case and keep away from media, including social media. At the end of the trial, the judge will provide the jury with instructions and the final verdict is achieved. Unlike what we see on TV, rarely is there a hung jury or a jury that cannot come to a decision. If a jury is deadlocked and cannot reach a verdict, the judge will declare a mistrial and a new trial may take place. Jury service is a fundamental right guaranteed to all U.S. citizens. It is a civic responsibility that connects all of us, and it is one of the very important aspects of our democracy.